three sovereigns, some 144 members of the United Nations are known to have abolished the death penalty, either in law or in practice. In the Caribbean, out of 15 members of the Caribbean community known as CARICOM, about half of them have also ended what is otherwise known as capital punishment. In many cases, some countries, including Trinidad and Tobago, are given as retentionists, essentially as a means of placating public opinion. The last hangings took place in this country in 1999. More and more, the world is said to be waking up to the conscience of human rights that the death penalty is a relic of the past. But mine is not to argue the point here one way or the other, but simply to set the frame for the discussions which will follow on this subject. This as we move to recognize and to observe the World Day Against the Death Penalty, with this event here this afternoon, sponsored by the EU Diplomatic Mission in Port of Spain and supported by those whom I mentioned at the top. We have two dynamic presenters looking on either side of the issue, in the persons of Mr. Israel Khan, Senior Counsel, and Ms. Leela Ramdeen. Before the presentation of their arguments, however, we'll get an insight into the status of the death penalty in Trinidad and Tobago from Senior Counsel Ms. Sophia Choate, the current president of the Law Association of Trinidad and Tobago, and then a case study of Mexico's journey to abolition of the death penalty. This presentation by Mr. Salvador Tinajero Esquivel, Coordinator for International Law at the Ministry of Foreign Relations in the Government of Mexico. And we'll have a question and answer session after the presentations. But let's kick things off with some opening remarks from His Excellency Ambassador Mr. Peter Cavendish, head of the EU delegation in Trinidad and Tobago.
Thank you, Andy. Ambassadors, High Commissioner, distinguished colleagues, ladies and gentlemen, it is indeed an honour to present remarks on the occasion of the World Day Against the Death Penalty on behalf of my colleagues in diplomatic missions located here in the Port of Spain. Once again, we are taking advantage of the occasion to continue our advocacy by sharing information, providing space for and participating in dialogues while giving prominence and visibility to all of the guidelines and evidence in support of total abolition. Working for the global abolition of the death penalty remains at the very heart of the human rights priorities of all states represented here. Similarly to the EU, our partners continue to voice strong opposition to the use of the death penalty as a cruel, inhuman, and degrading punishment. It violates the right to life, while not deterring crime more effectively than imprisonment. 73 years after the adoption of the Universal Declaration of Human Rights, we believe that the worldwide abolition of the death penalty is closer to reality than ever. Of the 193 UN member states, 162 countries have had no executions for at least 10 years. 114 have abolished the death penalty in law, and in the case of Trinidad and Tobago, the last execution was in 1999. We hope that this is in itself a favourable sign for the next steps towards abolition. In that respect, we look forward today to hearing from the experience of Mexico, a country like Trinidad and Tobago in that it too also faces challenges with high rates of crime and insecurity, but yet took the courageous decision to abolish the death penalty in 2005, a stance that remains today. This year's theme for the World Day Against the Death Penalty is Women and the Death Penalty. Although women represent a small percentage of global death sentences, gender-based discrimination continues to impact upon women at all levels of the criminal justice system. In some countries, women are sentenced to death at higher rates than men for offences linked to sexual morality, such as adultery. Moreover, mitigating circumstances related to gender-based violence and abuse are rarely taken into consideration during the criminal process. So it is fitting that one of the human rights projects implemented in partnership with civil society here in Trinidad and Tobago addresses the system of persons on remand, with persons incarcerated without trial for lengthy periods, with a special emphasis on female prisoners. To compound this abuse and in line with this year's theme, data from the International Human Rights Clinic of the Faculty of Law, University of West Indies, is particularly revealing. It indicates that female remand prisoners suffer double jeopardy given that a high percentage of them have been arraigned for murder in circumstances where they have been the victims of domestic violence, but that those circumstances were not taken into account in their charges. Another alarming pattern that emerges in terms of the makeup of the prison population is the correlation between the high percentage of persons in prison, their levels of income, the culture of violence, where typically such persons belong to the lowest income and least educated strata of society. What this implies is that if the death penalty is applied, given the disparities just mentioned, those predominantly affected will be low-income persons and women. The use of the death penalty permanently excludes the rehabilitation of offenders back into society for those who may be rehabilitated. With modern forensic techniques, many convictions have proven to be unsound. There's no possibility of restoring those innocents who have been executed. For those concerned about high crime levels and who've convinced themselves that if the death penalty is enforced, crime will decrease, the evidence is clear. There's no such correlation. Moreover, it should be noted that the same arguments which link history, morality, and culture in support of retention are also used across the world to systematically deny individuals and groups their basic human rights. The state and agencies that are collaborating on today's activity are all involved in comprehensive support to government and to civil society actors to address crime and insecurity and to provide an enabling environment to ensure that all human rights are respected. Importantly, we are available to meet with any sector or agency to discuss the position of those in support of retention. We are therefore looking forward to a productive discussion, which we hope will continue beyond today's activity. Thank you.
Well, thank you very much, Ambassador Cavendish. Ms. Sophia Choate is the Senior Counsel, President of the Law Association of Trinidad and Tobago. She's been in practice since 1989. She's appeared for the prosecution and for the defense in cases involving the death penalty and has been involved in constitutional motions filed on behalf of persons on death row. She's been an independent senator in the Parliament of Trinidad and Tobago in the period 2015 to 2020. She's a former vice president of the Criminal Bar Association in this country and a former member of the Law Commission and of the Mercy Committee. Sophia Choate, SC, provides us now with a status report on the situation regarding the death penalty in Trinidad and Tobago.
Thank you very much, Mr. Moderator. Mr. Moderator, Your Excellency Peter Cavendish, ambassadors, diplomats, panelists, viewers looking on. I want to begin with a disclaimer. Even though I am the president of the Law Association of Trinidad and Tobago, I do not speak on behalf of the Law Association of Trinidad and Tobago, which has not yet taken a position on whether the death penalty should be retained or not. I would imagine it is a matter on which our members might be quite divided. Now, there are 44 persons on death row in Trinidad and Tobago, according to my research. Murder remains a capital offense, despite the fact that there have been recommendations for consideration to be given to the categorization of murder coming from public officials, including our Director of Public Prosecutions. In any event, it has been well over 2 decades since anyone has been hanged in this jurisdiction. I think we need to look at the debate or the issue in the context of the development in the law with respect to what we consider to be due process. Section 4 of our Constitution, that's to say the Constitution of Trinidad and Tobago, contains what we refer to as entrenched rights. One of those is the right to life and the right not to be deprived of it except by due process of law. In constitutional cases, due process of law, this phrase, has become somewhat of a term of art. One of the classic cases which considers its meaning is that of Thomas and Batiste, a case which was taken to the Judicial Committee of the Privy Council, which is still our final court of appeal. In that case, the court said, or the committee said, that due process of law invokes the rule of law itself, the universally accepted standards of justice observed by civilized nations which observe the rule of law. It is not something immutable. It is not fixed in time. The Privy Council's interpretation of this phrase coincides with the interpretation given to it more recently by our Caribbean Court of Justice in the case of Flowers. Why is understanding and interpreting this phrase so important to us? Due process of law includes transparency and accountability. Generally speaking, trials are conducted in public, Members of the public may attend, as may interested parties, such as relatives of the victims and relatives of the accused. Trials may be reported in the media, and the processes used during the course of a trial are clear to all stakeholders in whose name the prosecution is being brought. Earlier this year, it was reported by Guardian Media in Trinidad and Tobago that our Honorable Attorney General had been asked about implementation of the death penalty after a particularly gruesome spate of murders. While he said that the government's policy was not against hanging, he is reported to have said that the wheels of justice have to speed up before unraveling the rope. He was of the view that there were processes to be fixed if you wish to carry out hangings lawfully. My understanding of this, and I could be wrong, is that the Honorable Attorney General was saying that hangings could not take place under the existing system, perhaps because the time from charge until the end of the criminal process, that is to say, the final appeal, takes such a very long time. Having regard to the impact which the pandemic and continuing court closures have had on the criminal justice system in Trinidad and Tobago, it is my view that the system has slowed down tremendously. The backlog, which was considerable pre-pandemic, is now expected to be considerably larger. And there are now persons awaiting their first trial for periods of time such as 8 years and more. There are persons awaiting retrials for periods of time over 15 years. That cannot be acceptable in any state or from any point of view. This is one challenge in my view, which we face with respect to cases such as these. It is also my view that the process post-conviction meets neither the test of accountability nor transparency. The Mercy Committee, which hears applications for clemency, sits when meetings are scheduled by the minister responsible. Let us just say that these meetings, at least in my experience, seem to fall low on the priority list, having regard to the heavy portfolios of the ministers responsible. The material placed before the committee is what is given by the Secretariat. Members of the Secretariat, and I do not know how large it is now, may not be legally trained, so they may not necessarily place all relevant material for consideration by the committee. The fact is, we simply do not know. The entitlement to be heard is a fairly recent introduction during this process, and the procedure for such may vary depending on whether the applicant is represented or not. The committee regulates its own procedures, so to the best of my knowledge, there is no set procedure which is accessible by the applicant or indeed interested parties. The committee recommends, but the minister is not necessarily bound to accept their recommendation and may recommend something entirely different to the President of the Republic. This introduces, in my respectful view, a political element only in the sense that the minister is a politician to the process, which in my respectful view does not rest easily within the concept of the rule of law. Even when the Mercy Committee recommends clemency, the applicant does not know what the recommendation is until bureaucratic protocols at the Office of the Solicitor General are completed and a pardon is prepared. This lack of transparency in the process leads to a sense of mistrust in the process, which undermines it. For example, when we celebrated our 50th anniversary as an independent nation, there was some talk amongst public figures about pardons for 50 prisoners serving very long sentences. Some of them had grown quite old, some were terminally ill, and so on. Then nothing was heard about the matter. If this information had been put about in error, then that ought to have been cleared up. If there was a change of policy, then that ought to have been clearly stated. Opacity serves None of us, and is certainly inconsistent with my understanding of what amounts to due process of law. After a death warrant is read, the convicted person is allowed brief visits with his family members, his attorney, and a religious advisor. The process of the execution is witnessed only by agents of the state. As sometimes occurs with hanging, the process may go wrong. The government pathologist is brought to the prison to perform the autopsy. The secrecy about keeping the body at the prison instead of taking it to the Forensic Science Center is grossly unacceptable. If we wish to continue to say that the death penalty may be humanely carried out, then these processes must be transparent. We can make no assumptions when ensuring that the person being deprived of his right to life is receiving due process. Finally, and this is on a more interesting note, there is a case before the Privy Council from this very jurisdiction, the case of J. Chandler, which is listed for hearing before the Judicial Committee on the 3rd of November, 2021. And the committee is going to consider whether the mandatory sentence of death for the offense of murder is unconstitutional. The outcome of it, I'm sure, will be of interest to all nations which still have the death penalty. Thank you, Mr. Moderator.
Well, thank you very much, Ms. Short, SC. Some things in there already for us to chew on about the question of transparency and the process, to what extent that goes to the benefit or the denial, the diminution of the benefit of those so considered. We'll hear now from Mr. Salvador Tinajero Esquivel, the coordinator for international law in the Ministry of Foreign Relations in Mexico, a case study on Mexico's, what is called Mexico's journey to abolition of the death penalty. Senor.
Muchas gracias. Thank you very much for the invitation. I thank the European Union as well as the delegations inviting our own embassy to invite me to this event. I am honored to be with Madame Schott here, and I'm very happy to be with the Friends of Trinidad and Tobago, a country that I personally have close to my heart. Just to give a brief account on how Mexico got into the abolition of the death penalty, I will give a bit of a background. Since independence in 1821, our first constitution was centralized, but then it was a federal constitution, and even though this constitution did not say anything about the penalty, nor prohibiting or not contemplating it, it was in the federal level, in the state level, at the level of the states, the criminal regulations established the death penalty. Then we had a new constitution in 1857, and despite of the fact that many of the constitutional drafters didn't want the death penalty, it was included in the text of the constitution as in the understanding that it will prevail until the situation of the penitentiary situation was solved. We have to understand that in these times we were in between an intervention by the United States and another intervention by France, and the debate finally decided to keep the death penalty for specific crimes. It took out the political crimes from 1857, but it left it for treason in foreign wars, understanding the particular situation that was at the time in Mexico. Then we had the revolution in 1910, and as a consequence, a new constitution, that is our current constitution of 1917, And Article 22 of that same constitution retained the death penalty more or less in the same terms of the previous constitution for a crime, for the gravest crimes such as treason, such as murder, such as kidnapping, and such as theft in the roads. But it stayed there. Therefore, it was as we have a criminal system that is based in at the state level. It's mainly states who apply the criminal law, except for certain offenses. We have to see how the criminal codes in every state and the military criminal code established it. In the federal level, the Code of 1871 established that the death penalty was not acceptable, and but anyway, given the circumstances, as I said, this was 7 years after the French intervention, so they decided to keep it for the crimes of treason at the federal level. But then the federal code in 1929 abolished the death penalty. So in the federal level was not applied since then. Then in the state level, it was retained by several criminal codes until 1975. The last execution in Mexico being in 1961, nevertheless, even though the criminal codes had it until 1975. The criminal code, and the military criminal code also had established the death penalty until way 2005. The last execution that was recorded was in 1961. Since then, no execution was carried out. Nevertheless, the criminal law allowed it. And the last civil, this was a military execution, and the last civil execution was in the late 50s as well. Given this situation, and in order to adapt the Mexican legislation to the principles of human rights, in 2005, it was officially abolished in the Constitution and in the criminal code and in the Constitution, the death penalty. Therefore, Article 22 of the Constitution was reformed to prohibit the death penalty and to include such a penalty in the list of prohibited punishments such as torture, marks, wiping, mutilation, etc. So it includes the death penalty under this list. So it is effectively prohibited. Now, our legal framework, as well as we have incorporated treaties such as the Inter-American Convention of Human Rights and the Covenant on Civil and Political Rights. Our own constitution, based on these treaties, does not allow Mexico to reestablish the death penalty. Nevertheless, there are always voices calling for it. So our position is, as well as in the world, it's a call to all the states that still retain the death penalty to eliminate it because we consider it as inhuman treatment. We understand that international law doesn't necessarily prohibit it yet. The penalty, there are heated debates at the UN, there are heated debates at the OAS as well. Our biggest neighbor in the north, it's a retainer of the penalty, for example, and there is a lot of debate regarding this. But our position is that it should be abolished. And going to our northern neighbor, just to give you an example, in 2003, we, as a de facto abolitionist country, sued the United States, presented a complaint before the International Court of Justice in the famous Avena case. It was regarding 51 Mexicans who were not notified on their consular rights, and death penalty was imposed on them. So they didn't have the chance to go. What we pursued here was something that we had seen over the years, that death penalty is extremely linked to ill representation. So those persons that were able to contact the consulates and guarantee a good defense were never imposed the death penalty, while people that didn't have this chance had, in many cases, the death penalty. So we saw this link in between the imposition of death penalty and lack of good representation, and therefore we went there and we established, after the ruling that was in favor of Mexico, we established a permanent program to represent Mexican nationals in the United States that may face the death penalty, or that are accused of an offense that may be punishable by death penalty, and it has been quite successful in not allowing any person to be or Mexican nationals to be punished with the death penalty. And I just want to briefly tackle about some numbers. As I said, we abolished the death penalty de facto since the early 60s. And if we see the numbers of the crime rates, they have been decreasing actually from the 50s to date. And here I want to make a differentiation. We as the representative of the European Union said, we face some security challenges now. But if we see the graphics and the numbers, they are more related to organized crime. So what have we seen? That ordinary crime is rather reduced since we don't have the death penalty. It's by any chance it's not growing in numbers. It's around in between 5 and 10% for every 100,000 inhabitants. While before the 50s, of course, this is raw numbers only, but before the 50s, we reached the level of 40 or 45 murders for every 100,000 inhabitants. So we, in fact, have this problem, but we have seen that the death penalty is not only not a deterrent, but it doesn't allow us to focus on the real problems. Many of the problems, as I said, are the organized crime that is also fueled by, for example, smuggling weapons from soft regulations in the United States or the European Union that are doing that. So we reach to our partners, in order to try to tackle these problems and try to get to the origin of the violence. We also recently sued the gun manufacturers in the United States, since we have detected that the crime rates are increased since these gun regulations have gone softer. So we found there more a correlation in these policies than in the application of the capital punishment. Since and I will be very happy to provide you with this data, but the fact is that the number of homicides has not been increased since we don't apply the death penalty, and actually our lowest number on homicides is in 2007, 2 years after we abolished the death penalty, and that the violence has other sources, and we have to tackle all other sources. That's a bit in a 10 minutes. I think I barely passed the limit, but the history of Mexico's abolition of the penalty, it has been a good model, since we have seen that it helps us to also to work more in prisons and in other topics that and focus on the real problems of the high crime. Thank you very much.
Andy, you're muted. Andy? Andy, you're muted. Have you introduced me? Does Andy know he's muted?
Looks like he's trying to fix it.
Oh, okay. All right. Okay, all right. Aha, Your Excellency, Mr. Moderator, panelists and viewers, let's ponder over the words of the French philosopher, author and journalist Albert Camus. He said, "What then is capital punishment but the most premeditated of murders, to which no criminal's deed, however calculated it may be, can be compared?" Federico Mayor, who is the president of the International Commission Against the Death Penalty, rightly states that rejecting capital punishment is about choosing what kind of society we want to live in and which values, including human rights and dignity, democracy, and the rule of law, we want to uphold. Like him, I believe that the right to life is the most basic of all rights because it is a prerequisite for the exercise of all other human rights. In March 2015, Pope Francis, the Catholic Pope, said, "For the rule of law, the death penalty represents a failure as it obligates the state to kill in the name of justice." The Greater Caribbean for Life, of which I'm chair, and the Catholic Commission for Social Justice, of which I'm also chair, oppose the death penalty in all cases without exception. We believe that any approach that prioritizes capital punishment as a crime reduction strategy is doomed to fail. It is often used in a disproportionate manner against the poor, minorities, and members of racial, ethnic, political, and religious groups. For example, as you may have read, on the 24th of August, after spending 26 years on death row in a Mississippi prison, Sherwood Brown became the 186th person since 1973 to be exonerated from a wrongful capital conviction and death sentence for murders he did not commit, due to false expert forensic testimony, as well as the perjured testimony of a jailhouse informant. Of the 186 persons in the USA who have been exonerated, 100 of them have been African American. I have been on a speaking tour in our region with Juan Melendez Colon, who spent 17 years, 8 months, and 1 day on death row in Florida for a crime he did not commit. He couldn't speak much English. He had recently, at that time, arrived in America. He couldn't afford an attorney. He was convicted and sentenced to death within a week, even though there was no physical evidence against him. Had it not been for the fortuitous discovery of a transcript of the taped confession of the real killer 16 years after one had been sentenced to death, he almost certainly would have been executed. Ultimately, it came to light that the prosecutor had systematically withheld exculpatory evidence. As the saying goes, capital punishment is for those who have no capital. Note that in our region, St. Vincent and the Grenadines has no legal aid system. The UN, in its document Principles and Guidelines on Access to Legal Aid in Criminal Justice System, encourages member states to consider, where appropriate, the provision of legal aid and to provide such aid to the maximum extent possible. Principle 3 states States should ensure that anyone who is detained, arrested, suspected of, or charged with a criminal offense punishable by a term of imprisonment or the death penalty is entitled to legal aid at all stages of the criminal justice process. The UN recognizes that legal aid is an essential element of a fair, humane, and efficient criminal justice system that is based on the rule of law. Legal aid is a foundation for the enjoyment of other rights, including a right to a fair trial. And also see Article 14, paragraph 3D of the ICCPR, which refers to the right to legal aid if the person does not have sufficient means to pay for it. And as we know, last year's focus for World Day of the Death Penalty was on the issue of competent counsel. The American Bar Association states that legal competence is measured by the extent to which an attorney is specifically knowledgeable about the fields of law in which he or she practices, performs the techniques of such practice with skill, manages such practice efficiently, identifies issues beyond his or her competence relevant to the matter undertaken to the client's attention, properly prepares and carries through the matter undertaken and is intellectually, emotionally, and physically capable. We know that many have not had competent counsel. It's worth noting the conclusion of a Caribbean regional conference on the abolition of the death penalty held in Guyana in November 2015, organized by the EU in partnership with the International Commission Against the Death Penalty. I was a participant in that conference. Inter alia, participants stated that the risk of executing innocent people exists in any justice system. And no matter how developed a justice system is, it will always remain susceptible to human failure. Unlike prison sentences, the death penalty is irreversible and irreparable. And I can share recommendations from that conference with you later. The death penalty lacks a deterrent effect. As stated by the General Assembly of the UN in 2007, there is no conclusive evidence of the deterrent value of the death penalty. It is noteworthy that in many retentionist states, the effectiveness of the death penalty to prevent crime is being seriously questioned by a continuously increasing number of law enforcement professionals. And you should read what Justice Arthur Carlson and Justice Johan Carigla said in 1995 about the constitutionality of the death penalty in South Africa when they abolished the death penalty. 11 members of the Constitutional Court there abolished the death penalty. Justice Carigla stated, no empirical study, no statistical evidence, no theoretical analysis has been able to demonstrate that capital punishment has any deterrent force greater than that of a really heavy sentence of imprisonment. Therefore, it simply cannot be reasonable to sanction judicial killing without knowing whether it has any marginal deterrent value. And the presiding judge, President Arthur Carlson, said that we would be deluding ourselves if we were to believe that the execution of the few persons sentenced to death during this period and of a comparatively few other people each year from now onwards will provide a solution to unacceptably high rate of crime. In our Caribbean region, we're hoping we're striving to ensure that our region become part of the global trend to join the 144 countries, about 2/3 of the countries of the world that have abolished the death penalty in law or practice. Sadly, all our English-speaking countries in our region continue to hold on to the death penalty. While GCL and CCSJ condemn the rise of violent crime in our region and express solidarity with victims, it is important to focus on the needs of victims too. We reject the notion that capital punishment will act as a deterrent or foster respect for life or the rule of law in our communities. We believe that society has a right to protect itself from persons who commit heinous crimes, and offenders must be held accountable. However, we believe that non-lethal means are sufficient to defend and protect society from offenders. Our response to crime in our region, therefore, is a moral test for all of us. Any discussion of the death penalty must be considered in the context of, for example, nation building, character development of citizens, and so on. The death penalty constitutes violence against the dignity of the human person. Amnesty International rightly states the death penalty is a symptom of a culture of violence, not a solution to it. The challenge we face is to find solutions to the root causes of crime and violence. And in Trinidad and Tobago, as Senior Counsel Sophia Cho rightly said, we need to address the backlog, the scandalous, in my view, backlog in our criminal justice system. And if we are still spending 15 cents in the dollar on crime prevention, as was stated in the 2012 UNDP report, then it's likely that we won't make much progress. The national security get the second highest sum in our budget, and we're still spending only $15 on crime prevention. Maladou Karan, the economist, had highlighted the need for us to spend more. Trinidad and Tobago is the only country in our region that retains the mandatory death penalty on its book. Fear of crime and misinformation about the effectiveness of the death penalty influenced the public to bay for blood. However, research by the late Professor Roger Hood from Oxford University and Florence Simangal in a 2011 study in Trinidad and Tobago investigating attitudes towards the use of the mandatory death penalty for murder under our law showed that while 91% then were in favor of the death penalty, only a quarter, or 26% about, favored the current law under which the death penalty is mandatory for all murders, whatever the circumstances. The findings reveal that there is little public support for the mandatory death penalty and call into question the government's continued commitment to this inhumane policy. Removal of the mandatory death penalty from our law books could be the first step towards abolition. You will recall that when Sir Dennis Byron and the Caribbean Court of Justice's team of judges struck down the mandatory death penalty in Barbados in 2018, Sir Byron made it clear, and I quote him, he said, laws should not be calcified to reflect colonial times. Those who had colonized us, Britain and most of the European Union, except Belarus, have abolished the death penalty. Yet our English-speaking countries continue to hold on to it like a yoke around our neck. In Trinidad and Tobago, because of the overwhelming majority of those sentences that are not actually executed, there is in effect some form of alternative to the death penalty already in place. Currently, I understand there are more than 1,000 persons waiting trial for murder. The last person to be hanged in our region was Charles Laplace in St. Kitts and Nevis on the 19th of December, 2008. And as been said, Andrew Briggs was the last person to be hanged in Trinidad and Tobago in July 1999. While there have been no reported executions since 1999, Trinidad and Tobago continues to impose new death sentences. In 2019, there were 8 new death sentences imposed in 2020, I think, and 44, as Senior Counsel Sophia Cho said, 44 individuals are known to be under the sentence of death on death row. Many have been there for more than 5 years. Therefore, as a result of restrictions contained in rulings by the various Privy Council judgments, the sentences of some of those on death row will most likely be commuted through the prerogative of mercy. But as we know, the Mercy Committee has not been meeting very regularly. And even though our Attorney General had said that he set up a tracking committee to make sure that 5 years doesn't pass until they can, in relation to certain persons on death row so that they can be hanged, we know that's a forlorn dream. Well, forlorn for those who want to pop next. But for us who want to stop crime and not lives, we're happy that, in fact, hopefully there'll be some day when we will get rid of the mandatory death penalty and abolish the death penalty. It's time in Trinidad and Tobago that we abolish the mandatory death penalty for murder and replace it with an alternative sentencing framework that is fair, proportionate, and in compliance with the international human rights standards. And it is time the English-speaking countries in our region impose a formal moratorium on the death penalty. Today is Archbishop Desmond Tutu's 90th birthday. His words spur me on to act. He has said, there is no justice in killing in the name of justice, and no godliness in exacting vengeance. It is our duty to break the dreadful cycle of violence and the doctrine of revenge. Universal abolition of the death penalty is not a pipe dream. It is necessary. I end with the words of Ivan Simonovic, former UN Assistant General Secretary for Human Rights. He said in 2014, as long as the death penalty exists, there will be a need to advocate against it. So let us go forth from this event today, strengthening our resolve to stop crime, not lives, and let us build a death penalty-free world. Thank you.
Much, Leela Ramdeen. The case for the abolition of the death penalty, and let me just say, I'll go back to the presentation by Mr. Esquivel to wonder to what extent that was sort of extraordinary and courageous of the authorities in Mexico, which continues to be a high crime dateline, as we say in journalism, but the country took that step, the society took that step back then. All right, so let me just point out some of the things about that gives Leela Ramdeen the presence to make the kind of presentation she did. She wears somebody who wears many hats. She's an attorney at law, chair of the Greater Caribbean for Life. That's the abolitionist movement in the Greater Caribbean region, a regional civil society organization working towards the abolition of the death penalty. She's also chair of the Catholic Commission for Social Justice and secretary of the Council for Responsible Political Behavior and a consultant of the Antilles Episcopal Conference of Bishops, their commission on the integral human development. And she lived for more than 30 years in London, in the UK, where she had a varied career, including working as a deputy director of education and head of quality assurance in a London borough, as chair of the late Cardinal Basil Hume's Committee on the Caribbean Community. Since her return to Trinidad and Tobago, she served 4 years as a member of the Police Service Commission, I say that with a smile, and nearly 5 years as a lay assessor on Trinidad and Tobago's Equal Opportunity Tribunal. She's a prolific writer in the press in Trinidad and Tobago, writing for both the Catholic News and the Trinidad Guardian newspaper. Well, to make the case for the retention of the death penalty, Senior Counsel Israel Khan, he's someone who has been practicing criminal law for 4 decades and more, 20 years of which he's been a senior counsel. He established his own chambers in 1979 and over the decades has mentored many young attorneys who have gone on to great success in their individual careers. He was one of the first batches of attorneys graduating from the Hugh Wooding Law School in Trinidad and Tobago in 1979, and for the last 30 years has been a tutor at that very law school. He has served on numerous boards and committees, including that of chairman of the Legal Aid, chairman of the Firearms Appeal Board, and chairman of the Police Protective Compensation Committee, and a member of the Law Reform Commission. In 2011, he was a member of the Judicot Commission, and in 2008, he was involved in the inquiry under Section 137 into the conduct of the former Chief Justice Sharma, appearing as a counsel for Mr. Sherman McNichols in that matter. As a defense counsel, he has represented more than 500 murder accused, all of whom were facing the death penalty. And he has also appeared as a prosecuting counsel in several high-profile criminal cases, most recently appearing as state counsel in the Vindra Naipaul trial, in which the state was seeking the death penalty for 12 men charged with that murder. Mr. Khan is also the author of the book, The Scales of Justice, published in 1993. Mr. Israel Khan, The Case for the Retention of the Death Penalty.
Thank you, Andy. Am I on?
Yeah, we're hearing you.
Am I on?
Yes, we're hearing you.
Okay. Thank you, Andy. Good afternoon to all. I will confine my comments to the jurisdiction of Trinidad and Tobago. I am a partial abolitionist, in that it is my belief that the death penalty should be retained for deliberate, wicked, and atrocious murders, the worst of the worst. While appropriate punishment from reprimand and discharge or placing the convicted murderer on a bond to keep the peace, or imposing a sentence of life imprisonment or a number of years upon the convict. Thus, the offense of murder should be classified into first, second, and third degrees, and no bail for first degree, but discretionary bail for second and third. The death penalty should be reserved for first degree, and custodial sentences for second and third degree subject to parole. First degree classification will be deliberate, atrocious, and wicked murders. For example, when someone takes a fee for killing another. 2, when some deliberately kills a victim of crime in order to silence the said victim from giving evidence. And third, when a cold-blooded murder takes place as an act of revenge or for some other like reasons. Second and third degree murders will be instances where extenuating circumstances prevail. For example, killing under provocation, using excessive force in self-defense. Murders involving passion, crimes of passion, and young person under the age of 16 killing someone. The rationale for maintaining the death penalty is that life is sacrosanct. And if a man unlawfully takes another man's life in the circumstances of the classification of first degree and is duly convicted, then the convicted murderer has forfeited his right to live, and thus as a deterrent to other would-be murderers and retribution for the relatives and close friends of the murdered man or woman, the convicted murderer should be executed. On retribution, I quote Dr. Wolf Middendorf, a renowned criminologist, his book Punishment For and Against at page 11. Throughout the history of civilization, retribution or social retaliation was the most widely and continuously persistent goal of punishment. It continues to be a major ingredient of the present system of penal law in many parts of the world. No legislator can afford to ignore fully the so-called people's sense of justice, which is psychological reality. A penal practice which fails to satisfy the victims and the public desire for retribution will have undesirable consequences. Full confidences in the administration of justice may become weakened, and people may take the law into their own hands. Close quotation. It is quite true to say that the death penalty is a premeditated and cold-blooded killing of a human being by the state. A civilized society cannot afford to be emotional and thus build castles in the sky. At this point in time of our history in Trinidad and Tobago, we cannot afford to use scarce resources in an attempt to cure or reform a cold-blooded murderer. It is true that the ideal state, the utopia we should all strive for, is a civilized society in which we could afford the luxury of not executing an accused, duly found guilty for a deliberate, wicked, and evil, and atrocious murder. This is the end of my contribution, and I welcome questions. Thank you.
Well, thank you very much, Mr. Khan. And I think it's a good point at which to throw the discussion open. And I wanted to go back to something you said, Ms. Choate, as president of the Law Association. You said you're not sure what the Law Association's position on the death penalty is. So there's no position of the association.
No, we haven't polled our members on the issue. Well, recently, as far as I know.
Yeah, but there's no, from the best that you can tell among your colleagues, there's no sort of predominant position among members or leading members.
No, I don't. I think one of the reasons for that is because it hasn't exactly been one of the most important issues for consideration in the criminal justice process, simply because the last hanging took place over 2 decades ago. And I think people are more concerned with developments in the law and developments in procedure to ensure that trials are fair and that kind of thing. That seems to have engaged attorneys who practice at the criminal bar a bit more than debates on the death penalty.
Yeah, and you could ask whether you have a personal position that you might want to share.
Well, my personal position is that I am against the death penalty. I think that that is nothing new. It's not the first time I've said it. I have been practicing since 1989, so I'm pretty sure I said it on more than one occasion.
Okay. Yes. All right. And you hold to that position.
Yes, as an individual, but I want to make it clear that is not the position of the Law Association. The Law Association has not been polled recently to determine the views of its members.
All right, thank you very much. Well, I have more questions for each of you, but let me just go to, there's a list of questions that we have here with people anticipating the discussion and the debate. And so we have some questions that have been sent in. One of them goes back to this issue as to whether or not the death penalty contravenes human rights. You want to take that to begin, Leela Ramdeen, and we'll go around we'll come to Mr. Khan about that.
Yes. If we think about human rights, the right to life, as we say, particularly as Senior Counsel Sophia Choate mentioned in our Constitution, the right to life is entrenched in our Constitution, and it can only be taken away with due process. But as she had outlined, due process is not, in reality, there are many flaws in terms of our own due process. And so that right to life, in my view, is something we need to look at as to whether, in fact, we're really upholding that right to life. We have signed on to Universal Declaration of Human Rights, which again encompasses the right to life. Our own Constitution does that. But with that comes responsibility on the part of the state to do what's right in terms of due process. And there are too many flaws in our system, too many delays. As I said, it's scandalous, with over 1,000 persons waiting for trial. Some, the former dean of the Faculty of Law, Professor Rosemary Bell Antoine, appeared with a team before the Inter-American Commission on Human Rights, where she talked about some of the challenges in terms of people, their cases being heard, and some of them waiting. I think Sophia Choate also mentioned this. There was a man for 21 years waiting for his trial. Sean Luke, we just had the case of Sean Luke, a 6-year-old boy who was brutally murdered. It took 15 years before the trial came to an end, or was even heard and then concluded. That is not due process. Due process in the 21st century, we have to do better than that.
Thank you very much. Mr. Khan, how do you put those kinds of sentiments into the context of your proposition that the death penalty should be retained for, you say, what are wicked and atrocious and heinous crimes?
First of all, our Constitution does not guarantee the citizen the right of life unlimited. The right of life is subject to due process. And once you have a fair trial, that is due process, not allowing you to live and being incarcerated for a long period of time before you get a trial. It's different from having the right to live if you are convicted under due process. It's two different things.
Yeah.
Are you telling me if a nation is at war, you do not have the right to kill your enemy? Well, then we must say that if a nation has war, they must not kill their enemies. They have an unlimited right to life.
All right, Mr. Esquivel, yes, you wanted to comment. Go ahead.
No, just to tackle on the from the Mexican experience on this. I certainly think that it's not, and I would agree as a lawyer that it's not the right to life is not absolute, but also as a human rights advocate, I would say that it's the basic human right. So we are on this two ways to go. The position of the government of Mexico is that it is because of that an unusual, as I said, a degrading punishment. But that's the position of the Mexican government. We understand that there are international restrictions to the imposition of the death penalty, but certainly not a universal norm. We have to go there. We have to get there. But that's a different discussion. In our perspective from Mexico, it is also not a deterrent. It is not a deterrent. As I said, since we de facto abolished as Trinidad and Tobago and many of the Caribbean countries have done de facto abolition, we had 40 years without with the death penalty in the codes and not applied, and therefore it stopped to be an issue as well in the society in Mexico. It started to be an issue when the criminality started to go up again, but then it was the time to say, well, we have to abolish it and go with the principles. But as we have seen, and there are many studies on this, the fact of not having the death penalty just brought down. I'm not saying there is a correlation on that, but criminality went down when we abolished the death penalty. Went down. There are many factors for that, and also went up not because of the death penalty. And as I said, not having this debate also helped us to focus on what is going on. We have a huge smuggling of guns coming from industrialized countries and from gun manufacturers, and that we wouldn't haven't seen if we are immersed on the debate. We have to see. We can focus. We have our criminal policies on where the true crime is coming. We understanding that we don't have a deterrent. I would be happy to show you how from 1961 the criminality of up to 2007 went continuously down, not having the death penalty with us. And before that, having the death penalty, the criminality was outrageous high. Thank you.
All right, thank you very much. I want to come back to you on a point about what might be public sentiment in Mexico as we speak. But let me come to you, Ms. Cho. There's a question for you. The death penalty matter involving Chandler, I think you'd mentioned that, will be heard before the Privy Council in a month, sometime in the next month. This will be hampered by the previous judgments of the Judicial Committee, where although the committee found the death penalty to be inhumane, they could not strike it down, as the savings clause, section 6 of our constitution, institutes the death penalty or insulates the death penalty. Don't we need to remove section 6 as a priority for the protection of human rights?
I think that's a very complicated question to answer because the savings clause applies to so many different pieces of legislation. I know that it is true that in the past, the Judicial Committee has refrained from saying that the death penalty is unconstitutional. But as they themselves have said in the case of Thomas and Batiste, due process is something which is not immutable. And I think that that is perhaps, though, that may be part of the discussion which will take place before the Judicial Committee when the matter comes up for hearing on the 2nd of November. I don't want to say too much about it because it's a matter awaiting to be heard before a court. And I don't want to presume to know how the learned law lords will determine the matter.
All right, thank you very much. Mr. Khan, let me come back to you on the question of retention. You know, I don't want to make this personal necessarily, but you know, I was a guest at the function that was held for you in your honor when you became senior counsel, and it was said in joke and in jest. You remember you had a matter in which you were the defense attorney and you argued the Lagahu defense, and some of your colleagues were saying, well, I mean, it was a brilliant defense that I think you won, but that so it was. You were seen as sort of walking a tightrope there and a fine line on that. But the more broader question is, how do people view you as such an effective defense attorney, yet you stand on the side of partial retention of death penalty in any case? How do you deal with that?
Well, I'm sometimes prosecuting small cases. It's very easy for an attorney because if you believe in a presumption of innocence and the onus is upon the prosecution to prove the guilt of the defendant, and they could only prove that if the evidence is cogent, compelling, convincing, and credible. that the jury must be satisfied to the extent that they feel sure, well, you can defend a person. And once the jury return a verdict of guilty, that is the end of your role. If you are prosecuting, your duty as a Minister of Justice is to be fair to the accused and produce evidence which is cogent, compelling, convincing, and credible. It's a very high standard to bring home a conviction against an accused person for murder, very, very high, And if an accused person is found not guilty, that doesn't mean he is innocent, with all these people locked up in the United States, and then they're letting them out. What it means that the evidence adduced against them didn't reach a standard of proof beyond reasonable doubt. It does not declare them innocent. It depends, the state didn't prove that they are guilty. You see, life is sacrosanct, but the abolition is not recognizing the life of the victim. They're recognizing the life of the murderer. I am not that way. If life is sacrosanct, don't deliberately kill somebody for a fee or for revenge.
Yes, thank you very much.
Can I just add,
Go ahead.
Andy,
Go ahead.
that
Go ahead.
we've been working with a number of victims who don't want the death penalty. So I agree that, in fact, the states, not only Trinidad and Tobago, really the victim loses out in lots of ways. As the mother of Sean Luke says, there is no justice for me as a mother. Rennie Cushion, who has worked, he's a man on Congress, his father was killed, and he formed victims against murder victims against the death penalty in America. And he's been on speaking tour with me, as well as others. Who Angela Cropper, we'd remember, whose members of her family were brutally murdered here. Until she died, she stood against the death penalty. So it's not all victims, but there are restorative of justice and transformative justice processes that can involve victims to give them some kind of healing and some involvement in the process. And these are things that we need to look at if we're looking at alternatives to the death penalty. Don't leave the victims out.
Yeah. How do you respond to this question, Sophia Choate? Somebody's asking, the death penalty is something you all seem to be afraid of. Why?
Well, I'll ask, who is you all?
Well,
We are in favor of life, as every person here. It's just we think that it's not. We are not afraid of it. It's just useless.
Could I just say, Andy, just to finish off,
yes.
it's not that we are afraid of the death penalty. It is just that I have seen how things can go wrong. Remember, in this country, we had the illegal hanging of Glenn Ashby.
Glenn Ashby, yes.
And there was a commission of inquiry into how that came about. I was one of the witnesses at that inquiry. And the evidence which came out and which is recorded is quite appalling. I would suggest that anyone who is interested in the debate at all should try to get a copy of what that inquiry found, having heard evidence from relevant parties. So if the death penalty can result in an illegal hanging where officials of the state go outside of the ambit of a court order and take a man's life, then certainly that is something that any lawyer who has taken an oath to practice law in Trinidad and Tobago should be concerned about.
Yes. And I was very close to that because I was covering it as well. And I could tell you that when the hanging took place, the person the prisons officer whose job it was to go and take Glenn Ashby out of his cell and take him to the hangman, when he realized what he was going, he described to me what transpired. And I met with that gentleman about 5 o'clock the afternoon afterwards. And he was by himself nursing a bottle of rum in in a club in downtown Port of Spain. And he told me before he went to that club, he had polished off a bottle by himself in another club in Belmont. And so that was the effect of it on him. And again, when with the 9 hangings we had in 1999 with the old Shady Gang, my own view is that the then Commissioner of Prisons never recovered from that. Leela Ramdeen?
Yes, yes. And
May I comment
sorry,
on that, Andy? Andy,
Go ahead.
what Glenn Ashby was not illegally hung. Glenn Ashby was legally hung because a jury found him guilty. His matter was before the Privy Council, and there was no respite warrant stopping that hanging. There was a convention that if a matter is being discussed at the Privy Council or any higher court, you do not carry that out, that order. There's no court, no inquiry they said.
But wasn't there a stay
There
of
was an
execution?
order.
was a
There was an order.
Oh, yes.
Yeah.
There was an order from the Judicial Committee of the Privy Council.
Yes.
There was
Yeah.
no order because
There
was
was-
no.
There was, that was the matter in the court, and
Yes.
the late Sherman McNichols was the person who was to coup and inform the prisons of the order having been given.
Yeah.
And somehow that didn't happen, and the man was hanged the next morning,
Yeah.
early o'clock before anybody found out.
In
what
fact,
transpired.
Mr. McNichols had been ordered by our Court of Appeal to return to the court. I think it was at 6 a.m. And instead he found himself at the Port of Spain prison participating in an illegal hanging.
Yes. We have
Because he
gone
was-
down
he
in
was-
history as having performed that illegal thing. Gregory Delzin, who was involved in that case too. You listen to him, the man was eating a mango. Now, if you've committed a crime, one must be accountable. But the state cannot be involved in this kind of illegal hanging. And can I just mention, what I wanted to mention, Andy, is while we're focusing only on the death penalty, the UNDP report on human development and the shift to better citizen security in 2012 rightly says that we have to get a better balance between legitimate law enforcement and preventive measures. And preventive measures into why are there so many crimes in our country and in our region? What are we doing, as they say, about youth development, education, job creation, addressing poverty and social exclusion, strengthening family life? Those are some of the things. If we want to stop thinking about popping necks, how are we developing integral human development? Is the development of each person. You walk around places like Sea Lots and Maloney and Laventille and see, are we developing our people? So when we talk about the death penalty, we have to link it with the development of our democracy. And democracy, as our first Prime Minister rightly said, it involves so many things. And it involves making sure that we care for all our people. And don't just wait until they commit crime and say pop next. No, we have a lot to do. People say we are fledgling democracy. We've been around long enough to be able to do better than say let's hang them.
We've been fledgling long enough as well.
Long enough. Oh gosh, we're adults now.
Yeah.
We've come of age.
You know
Yeah,
what the
but
Privy Council decided in Pratt and Morgan? The Privy Council decided in Pratt and Morgan that a convicted murderer has a right to be executed, and he must be executed within 5 years. And if you don't execute it within 5 years, they say forfeit that right. They didn't say you ought not to be executed. They say you have the right to be executed, but you must be executed within 5 years
Since
of the date of conviction.
Since Pratt and Morgan, there have been a number of other cases. There's a case of Guerra and Baptiste in which the Privy Council said 4 years and 10 months is too long. And then there was Bahamian case of Henfield, and the Attorney General said 3.5 years was too long. And then Trinidad and the Queen, as we know from St. Vincent and Grenadine in 2009, it brought out the two key principles about the worst of the worst, etc. And there's the Bahamian case of Ernst Lockhart and the Queen. There's so many cases since Pratt and Morgan that have made it clear, as the Death Penalty Project rightly said, the courts really have gone as far as they could. And now to outlaw capital punishment, it seems as though we need it's a political issue. The politicians have to be courageous enough and have a vision about the kind of society we want to create to be able to take this further. So let's not only focus on Pratt and Morgan, let's look at the other cases that have come since then. And let's look at, although people thought the CCJ would be a hanging court, Thank God for Sir Dennis Byron, who said we cannot calcify our laws in colonial time. Get rid of the savings clause and let's become real human beings. Sorry.
All right, you wanted to come in there, Sophia Chud?
There's so many things which have been said, so I'm not quite sure which one I ought to comment on. But I do agree that, much has changed since Pratt and Morgan.
Yeah.
And unfortunately, what we have also seen, it's a phenomenon which we have observed from the Judicial Committee of the Privy Council. It's fair to say that they have not always been consistent in their interpretation of the constitutional principles, which sometimes swing one way and then swing another. So certainly we would like to see some sort of development of the law instead of, how should I put it, swings in policy almost that we have witnessed in a few cases. So what I look forward to in the case which is coming up in November is perhaps a greater elucidation for us, especially in light of what the CCJ has said in the case of Flowers, a greater elucidation on what amounts to due process of law.
Yeah, and with your proposal, Israel Khan, for the death penalty to be retained for the categories of murders that you're suggesting, well, where's any evidence of any movement on that as a sort of compromise in the public mind? Because the view is that this state, as well as others, part of the reason for retaining the death penalty is to appease public opinion. So if cases can be made out as we move forward with these aspects of human rights, and in some cases, how I look at it to some extent is that the abolition of the death penalty is of a piece with greater awareness about environmental protection, and matters of that sort. So if that were to be a halfway point between total abolition and total retention, where's the thrust towards that in your view, and why do you think it's not happening?
Well, 20 years ago, I made that submission before the Prescott Commission, and he recommended we have first, second, and third degree murder. It will be abolished eventually, Eventually it will be abolished. But I am saying we have not reached a stage in Trinidad and Tobago to abolish death penalty. And let me tell you how the Privy Council will rule. The Privy Council will rule in accordance with their own narrow interests. Because for 400 years, they ruled that slavery was legal. And when it was no longer profitable to them, they got up and discovered we were human beings. So the Privy Council and other courts who govern us are ruling and setting our law. We shouldn't go there. We should have our own CCJ. And in relation to Mexico, I just look at a movie called with a Joe Blood, Chapo, where he admitted he killed 30,000 people or 3,000 people, and Mexico decided they're not going to extradite him to the United States unless they get a guarantee they won't execute him. What about Pablo Escobar? What about people just killing people left, right, and center? What should we do? If your nation is at war, would the abolitionists say, don't kill your enemies? That's what I want to know. Don't kill your enemies.
Okay, and let me get someone else. You want to respond to that, Leela Ramdeed? Can we make a connection between a declaration of war and people operating in their own rights on the streets of any country?
Yeah, I think those are two different issues and we mustn't confuse the two issues. Let's focus on the death penalty. 144 countries cannot be wrong. 100, there are only a few countries, 18 countries that that executed people last year. There are 5 key ones, as we know. China, where we don't know how many there, Iran, Iraq, Egypt, and Saudi Arabia. Those are the 5. But everywhere they had only 18 countries out of 193 or whatever. So we go in and the world is moving away from that trend. And I feel that the world is moving in the right direction because nowadays the countries have we're technologically advanced. We can protect society from people who want to commit heinous crime. The challenge is we cannot rehabilitate if we don't have facilities, detention facilities that will allow for rehabilitation. And it must be Andrew Douglas. We've had him on our panels. He was on death row for years. He has been rehabilitated. He's still in prison after 30 years. But he runs he's a host on the radio, the prison radio, etc. Human beings, there is a spark of divinity in all of us. And that's what our church changed its catechism, because at one stage there was a loophole that said, states could kill. But now 2267 in our catechism has been changed. Under no circumstances do we accept that the death penalty should be used, because we have to accept that we're born with an inherent dignity that you never lose, no matter how heinous the crime. There is a saving grace. People like Andrew Douglas, just talk to him. He's talking to a lot of school children and others to tell them stay away from crime. But he was one man who would have been executed, and he has turned his life around. We need to look at some of the things that, for instance, in the case of Max Otido and the Queen, what the Privy Council said, if you're thinking of the death penalty, it's not enough just to submit a probation report. There must also be a consultant psychiatrist report, and later they said they might also need a clinical psychologist. One of the members on the Greater Caribbean for Life Executive Committee is Angelina Sukubob, and she said she read 2 of the psychiatrist psychologist report on the fellow who was the last one, Charles Laplace, who was hanged in our region. And she said 2 of the 3 reports, if he really had good counsel, competent counsel, he would not have been hanged.
And that's a whole other angle on the discussion about the competence of counsel.
Yes,
in matters
but
of that
it shows
sort.
really that
That's a program. That's a program in itself, a discussion in itself, as well as the idea of people like Andrew Douglas and others who are being trotted out as exemplary prisoners. We don't have a proper parole system, so that they could have been outside.
For 4 years, Andy, I sat on a cabinet-appointed parole introduction committee here in Trinidad and Tobago. 4 years. There were government ministers on that committee as well. We produced a brilliant report. I would say it's brilliant because it took us a lot of time looking around the world. But it's collecting dust somewhere. It's collecting dust.
All right, Mr.
Andy, I'm sorry, I don't think that is entirely fair. Because the Law Association has been sent draft legislation.
Oh, you got it? Oh, good.
Dealing with a proposal for parole. And the Law Association has been asked for its comments. So I suspect that if it's not already laid in Parliament, it may
Thank God.
be laid shortly.
But we have to make allowances for the speed or the lack of it at which things get done in the country. That's what you're saying?
Yeah.
All right, Mr. Esquivel, you had your hand up.
Yes, thank you. Just to tackle on this last thing where they were talking about my country. I first of all, I perfectly understand like the position of the victims if they would like to have revenge on something. I can't imagine if someone does something to. I don't know how I will react then, but I am as a person, I am not the state, and that's one of the things as well. Mr. Israel was asking what would you do with these people? First of all, you can do better policing if they are not dead, for example, and I'm just putting random examples, but they can tell you where they got their weapons, so you can do better policing. They can tell you where they do the money laundering, so you can recover the money, the illegal money. So you can, as a state policy, you can be much better equipped if these people are alive or than if they are dead. But that's only one simple example, and the other is when the tackling on these topics. I know it's not the topic of the conversation, but in an armed conflict, of course, international law allows one soldier to kill another soldier, but that is lex specialis, and therefore the human rights norms have to be understood in an armed conflict in the logic of the lex specialis of international humanitarian law. That is another body of set of law, and therefore I think that's out of the scope of this conversation. And fortunately, none of Trinidad or Mexico or the European Union are at war now, but that is a different kind of issue.
All right.
Thank you.
All right. Well, thank you very much. It's unfortunate that you've got the last word, sir. Mr. Salvador Tinajero Esquivel. Thanks to you. Thanks to Lila Ramdin. Thanks to you, Israel Khan. And thanks to you, Ms. Sophia Chut. And our thanks also to Ambassador Peter Cavendish, the leader of the EU delegation in Trinidad and Tobago. Thanks to you in our virtual audience and all the people who helped put this together. I'm Andy Johnson. Thanks for being with us on this discussion.
Much obliged.
Thank you.